Okay, so today we're going to look at problem solving, legal problem solving, that is, how we go about doing problem questions specifically. Now, some of you would have attended the lecture that I did at the end of last half term about the mock coursework specifically, but I'm going to talk a little more in detail in this podcast firstly about actually writing problem questions. Once I've done that, we're then going to look at a brief part of a problem question, and we're going to attempt to answer that, or I'm going to walk you through how I would attempt to answer that. Now, as I said in the lecture, there are primarily two different models of answering problem questions that different academics will prescribe to. One is IRAC, and the other is IDEA. They stand for different things. I use IRAC. So this presentation is going to be in IRAC. Some of you, however, and you'll get this next year if you study human rights, will use the IDEA method, which is what Helen uses. She thinks those terms better fit what you do in a problem question. My personal opinion is that IRAC is easier to understand. So what does IRAC stand for? Issue, rule, apply, conclude. These are 4 steps that you take in a problem question. Now, you take them multiple times within a problem question because you do it for each independent issue that you come across. So imagine that you had 4 different shops like you do in some of the questions, or you have 4 different statutory provisions and it raises 4 issues. You would do this IRAC process for all 4 of those things. We do this process because it ensures that you contain in your answer everything that is necessary. Issues. You should, having studied public law and tort and contract, be able to read through a question and spot certain things in that question that you find legally relevant. And other things that are just damn right interesting or not interesting. And they're there to make the question fit. So, if it says John wears red shoes, what's his red shoes got to do with public law? But if John's the baker and he has a rival baker sitting on an appeals panel, you can see that that might have an issue of bias. So the issue stage is you being able to read through the question and go through it and spot all the things within that question that you believe might raise legal issues. This is important for 2 reasons. Firstly, everything that you do in your problem question should focus on the problems. That's why it's called a problem question. It's not called a what do you know or tell me everything you know about judicial review question. It's specifically targeted at the particular problems within that question. The better you are at targeting your answer to the things in the question, the higher grade you're likely to receive. The way that I sell this to students, or I inform them of how to go about this, is to imagine that this person has just walked in to your office. And rather than you reading an exam script, you're actually listening to this person tell you what's gone wrong. And as you're listening to them, or as you are in an exam reading the script, what you are doing is spotting the things in the conversation that might be legally relevant. And it's based off of those things that you're then going to offer advice. Once you've found all the legally relevant issues, for each of those issues, you have certain laws that exist surrounding those issues. So, for example, if you see a bias issue or an illegality issue, certain cases will come to your mind. After you've identified the issue in your problem question, you move on to explain, in brief terms, the legal rules surrounding that issue. The reason that you do this is that punctuates to the reader that you understand why this issue is legally relevant. Moreover, the next stage of the test is to take those cases, take those statutes, take those things, and apply them. Actually show why those cases or why those statutes allow you to come to the conclusion that you've come to. Now, one of the biggest mistakes that people make with a law exam is that there's no law. Without the law, the exam becomes redundant. The whole purpose of the law, or the exam, is to show your understanding of the law, to show how your learning of the law can be applied to somebody's circumstances. It's a logic test. I can show how much I've learned by applying the things that I've learned to future cases. It's how, as a lawyer, you would know that when somebody walks into your office, whether or not they have a particularly good claim. Because if you have a good knowledge of the law, of course, you'll be able to advise them of whether or not they should go forward with their case or not. Then you apply the law. This is where you say, well, I've explained this particular legal rule because it allows me to say that in your case, in this case. Now, in the past, some first-year students have actually written their problem questions as letters in their head. So they begin the opening saying, Dear Sandra, Dear Dave, Dear Emma, Dear Patrick. That way, as a letter, that stylistic change allows them to remain focused on solving the person's problems and prevents them from generic drifting off and doing whatever they want. And then finally, you offer some conclusions. Now, one thing to understand here is that what we do not mean by conclusions is necessarily a definitive outcome. It might be that you say that if a judge decided to apply a particular case, the outcome would be this. But if he didn't and he applied this other case, the outcome would be this. This is because it's very important for you to remember in drafting problem questions that you are not the judge. And there's no accounting for a crazy judge. The best advice you can offer your client is a balanced consideration of all the facts. In criminal law, people are always trying to prove their client's not guilty. Yet if I received correspondence from my lawyer informing me that I'm definitely not guilty, and then eventually I get found guilty, I wouldn't rate my lawyer very well. Similarly, if they hired you to explain to them whether or not they have a case in judicial review, and you unequivocally state that they do, if a judge was then to rule that they didn't have a case, you would look like a very poor lawyer. Therefore, by offering a balanced insight into what the situation is, you will offer a better legal service to your client, even if it isn't the legal advice they would necessarily want to hear. So what we have here then is a method whereby we outline an issue, we discuss the rules of that issue, we apply the law, and then we conclude. And then we go on to the next issue. Now, the best way to do this is chronologically. To go through the problem question, pick out the issues chronologically that are interesting. Now, to do this, we're going to briefly look at the question that you looked at for your mock coursework. If you remember, it was the Sex Workers Act 2015. Now, what I want to do is I want to look at one part of the question. If you look at section 4, if deciding a local brothel should be licensed, a local council must send an independent reviewer once a year to ensure the good maintenance of the brothel. We then go through, and once we read the facts, when you get to a particular paragraph, for example this one, a week after receiving her rejection, Emma also received the report for the inspection of the brothel. The inspector, John, the owner of a local brothel within Solent City, had given a negative report, and thus Solent City had decided to close the brothel. In the closure notice, Solent City stated Emma had no right to appeal. Now, if we think of it, this here is the thing that is legally interesting, isn't it, in regards to section 4. Because section 4 clearly states there should be an independent review. Whereas this states that it wasn't an independent review. Now, there are two issues here that raise two different points of law. Issue 1 is that it goes directly against the procedure outlined in the statute. Procedurally, you could say this here is ultra vires. So you could say, 1, this here is procedurally ultra vires. And 2, issue 2, of course, is what you can say is that there is a common law issue of bias. Okay, so now what's going to happen is I'm going to show you how you would do this problem solving, particularly in relation to this first point of procedural ultra vires. With the IRAC method, as I stated, you would begin by stating the issue. Well, firstly, it must be considered whether Solent City Council's decision to appoint John as the independent reviewer of Emma's brothel is procedurally ultra vires whether to appoint John as the independent reviewer of Emma's brothel is procedural vires as per section 4 of the Sex Workers Act 2015. Now, what you would do from here, of course, is you then have to think of what legal rule to discuss. So, to explain whether this is procedurally ultra vires, we must look to Allsbury Mushrooms Limited. Now, in an exam, you always underline your cases. Just as in coursework, you put them in italics. Obviously, you cannot write in italics in an exam, so you underline the case. So, Allsbury's, in Allsbury's, we can take it off underline now. It was held that when a minister of state fails, or when a member of the executive fails to implement a procedural requirement from within a piece of law, their actions may be deemed illegal on that basis. For example, in Allsbury Mushroom Limited, the Minister of Labour was required to consult any representative organisation that represented a substantial number of mushroom growers. As the Minister of Labour failed to consult the Mushroom Growers Association, which represented 85% of all mushroom growers, his actions were declared procedurally ultra vires. If we look for similarities can be drawn between this situation and Section 4 of the Sex Workers Act states, and we can go and look at Section 4, must send an independent reviewer, that local councils must send an independent reviewer. As John has an interest in the failure of Emma's brothel to maintain the success of his own, he is not independent. The decision of Solent City Council to appoint John to this position therefore might be considered procedurally ultra vires because it runs against, because it directly opposes. I don't like the word opposes there though. Let's have a look. It directly contradicts the statutory provision. Now here's then is our answer, and I'm going to make this smaller so I can fit it all in one screen and we can do this as an exercise. This is our answer to that part of the question. Firstly, it must be considered whether Solent City Council decision to appoint John as an independent reviewer of his office procedural authority. Now that bit, guys, I'm going to put in yellow. I won't put the text in yellow. What I'll do is I'll put the behind bit in yellow, because that's our issue. To explain whether this is procedural authority, we must look to Aylesbury. Aylesbury mushroom, it was how the member of the executive fails to implement a procedural requirement from within a piece of law. Their actions were deemed illegal on that basis. For example, in that there is our explanation of the legal rule. Similarities can be drawn between the situation in Aylesbury. Sex must independent reviewer, as John is an interest in failure of ruffle to maintain his own. That there is our application. And then finally, that there is our conclusion. So what we've got here is each of the 4 steps of IRAC. Now, what you need to realise is that in your exam, if you are to cut or reduce or make smaller any section of this analysis, the green part is the rules. You don't necessarily need this part here, the factual part, but you have to have all 4 stages to make evidence-based legal analysis that is applicable to your client.